Greetings and salutations, my fellow sovereigns. This is Saturday night Civics and 70 class of the Vocational Science of Freedom, and tonight we're going to be continuing our reading of a document titled U.S.A. the Republic that No One Lives in. We left off at page 12 at Federalism, and if you'd like to join the Vocational Science of Freedom Gilded server, you can do so by either going to the Vocational Science of Freedom YouTube page and clicking on the VSOF Gilded server icon in the upper right-hand corner of the banner. And also the invite for the Gilded server is also in all of the show notes, both on YouTube and on Odyssey. So let us get back to where we left off at. So there's no doubt about it. There's an economic advantage to individuals cooperating for business purposes, and our founders recognized that fact. What they did not want was the compelled performance of entrapment by the implied contracts under the private Roman civil law operating within and between the states. Theirs was to be a civil law based on the principles of the general common law and its full disclosure bilateral contracts. And just to pause here a moment to make his point is that that's why you see in both the federal and state constitutions, all of them, there will always be a clause in all the constitutions that states that there shall be no law abrogating the right of contract. And the reason that's in all of the foundational documents on both the state and federal level is because you have to have that protection in order so that people can freely do business between each other, and also so that the government does not have any absolute control over all of the commerce of a nation. So, just want to make that point. So I'll continue here. It thus became referred to as a system of commercial law in the American states. Under our unique type of law, the government was to have no direct contact with the people, unlike the Roman civil law. The federal government was there basically to oversee the economic cooperation between the several states of the Union, who were foreign to each other, to provide for their common defense and to work out the commercial businesses of the several states of the Union as they relate to each other and the world trade, this being based on public municipal law, not private law. The common law principles that our forefathers brought with them were the basis of public municipal law. This means, and the aspect of public law, I differentiate public law between public policy, and Roman civil law is that aspect of public policy that's actually trying to drive or herd, if you will, the people to do something or not to do something, where public law is an aspect of a harm and is constitutional. So, just so you know that. Okay, so this means that the laws are bilateral in nature based on two-party agreement, where there is a meeting of the minds with full disclosure. Nothing is implied or hidden, where one would be entrapped into compelled performance by a third-party trust, which is what happens in all the private for-profit courts now. The public municipal law was law that did not allow the private commercial government to have any relationship with the individual citizen and his right of contract. As I mentioned before, there shall be no law abrogating the right of contract. That's in all of the state and federal constitutions. This was true separation of power. Private law, which the Roman civil law thrived on, was conscience law of one quote-unquote person, trust, over another without their knowing how it happened. There was no liberty of choice as to its terms. The terms of the contract or agreement, also called an offer, are always based on the personal beliefs of the Roman civil government. The offer is always unilateral, where your acceptance is totally signified by your silence. And this is what they'll do, and just to pause here and make a point about this, this is what they'll do every single time you're in court. And it's also what's happening at arraignment, too, which a lot of people don't realize. What arraignment is under this Roman civil law system is you going in and agreeing to this offer, to this aspect of the unilateral contract. So the judge will say, do you understand the charges against you? Right? What he's saying is an offer. He's saying, Are you willing to be under the jurisdiction of Roman civil law and have the statutes, acts, ordinances, and codes have force and effect over you, is what he's doing. Because if you agree to stand under something, you are agreeing that it is above you. So when he says, do you understand, do you stand under the charges against you, he's creating that offer and saying, look, you don't have to be subject to Roman civil law, but if you want to be subject to Roman civil law, then therefore here's the offer. And that offer is then accepted by you by saying, yes, I understand the charges against me. Not even knowing that the charges aren't even against you, they're against a constructive trust which they created. The res of which, meaning the thing, comes from your estate, which is of course your body and the rest of everything that you own in law. That's the substantive definition of an estate. But in this aspect of them creating this offer, that's what they're doing. And if you do not say anything, meaning if you stand there and you don't say anything, you just stay mute, the judge will always say, let the record reveal that the defendant stands silent. Because what he's doing is then getting you to agree by your silence, which is absolute total fucking fraud and bullshit, in my personal opinion. Roman civil law is absolute garbage. It's a system set up by the Luciferian cult of Rome filth to fleece everybody. And it's a completely foreign system of law to us, as is clearly described and written down even in the very title of Bouvier's Law Dictionary. This law dictionary is of the American jurisprudence and the civil and other forms of foreign law, meaning calling Roman civil law foreign law, because it is. It shouldn't have anything to do with us. So anyway, I'll get back to reading here. There is always strings attached where considered a benefit. And that benefit, when you're talking about what I was just talking about regarding arraignment, the benefit is to go to jail. They consider that a benefit. Yes, they do. The agreement never has definite limits. What is agreed on is only implied or constructed upon the circumstances. The implications of a unilateral offer and acceptance would always create a third-party constructive or implied trust. Again, that's what they're doing with every court case. They're creating a constructive trust. This trust, being the third party, was always there to oversee and to extract what it thought it was due through compelled performance to the rules of the private trust that bound the persons who had private business dealings. There is no separation of powers. In other words, there is no way to have a true bilateral, general, common law contractual relationship because of the government having you in a trust relationship, making your position inferior, not superior. That's why they make you a trustee. So when you're going into any court and you agree to be the defendant, you are actually agreeing to be the trustee of the constructive trust that they just created out of the res that they pull from your estate. Okay? So to continue, you become the trust and I should say you become the trustee and therefore part of the government, while at the same time the government becomes you and part of the trust. You end up being your own enforcer as a volunteer. This is why IRS keeps telling you that taxes are voluntary. Your identity is lost in the trust relationship due to purely moral ideas developed outside the legal system because of movement away from law. Because it finds its chief reliance is on the power of the magistrate. And I wouldn't say magistrate there, I would say chancellor, because that's what they are. They're acting as a chancellor in a chancery court, where the black-robed priest of El literally, quote-unquote, holds the conscience of the king. That's where chancery comes from. So in order to have a separation of powers, each power must have and keep a separate and distinct identity. That is, the people function as sovereigns. The government operates only by the powers the people, as sovereigns, allow, and those powers, public law for private use, protects the identity of the people apart from the civil government. Roman civil law does not allow this. The federal government that was set up at the beginning was public commercial law, but it was based entirely on public municipal law for private use. The federal government had no direct contact with the people because the people had not contracted away their law and its separation of powers into a constructive trust of private conscience, which is what I was talking about with how they formulate every single court case and turn it into a constructive trust. The state is forbidden to interfere with the people's lives by the constitutional mandate of Article 1, Section 10, which refers to there being no, quote, law impairing the obligation of contracts, close quote, which is what I was talking about before. The individual owed nothing to the state, thus the state could not interfere with personal and individual contracts between individuals. Federalism, without Roman civil law as its base, public federalism, could not come into intervene with private contracts between two parties. However, when federalism is based on Roman civil law, private federalism, where both your identity and the government's are confused by the constructive trust arrangement, they are constantly a part of the contracts. They are the administrators of your conscience via the charitable trust. Another way to think about this, and part of the reason why they're getting away with this stupidity, just regarding this sentence that I just highlighted here, is that when you think about everything in the system right now, what they've done by removing lawful money is that they've created a situation where there are literally no lawful contracts in the public anymore because there's no lawful consideration being traded with the money as far as the transactions go. And so then everything is in this weird dual trust relationship situation, which is the way they want it. So it's important to understand that the money does have a part and parcel to do with this, but it really does stem from the original contract, the original birth certificate contract signed at the Foundling Hospital that abandons the child by document at the hospital, and that the state, the corporate state, then picks it up as basically a maritime admiralty salvage, if you will, and then administers that infant's estate throughout their entire life because they never rebut the presumptions. So, to continue. Under the Roman civil law, you are considered an incompetent. Okay, now this is the aspect of not only an infant, but also not being able to handle your own affairs, or being, in law, what would be called a lunatic. I've also seen this happen a lot in court too. So when you get someone that actually knows what they're doing and actually understands the whole entire system as to what is happening, what's going on, how it's being run, what they'll do is they'll then attack that person and say, well, we think we should have a hearing for competency. They'll call it a fitness hearing to see if you're fit to stand trial, right? So what are they trying to do? They're trying to bring up that last possibility of saying you're incompetent or you're insane or you're not fit to stand trial. Then what they'll do is they won't throw you in jail. They'll throw you into a mental ward for as long as they want to, because this is another way that they have capacity to administer you. If they can find you to be insane, or if they can find you, well, the presumption automatically is that you're an infant and that you have not been found to be living, meaning that you are not the lawful heir to the estate of which they've now turned into a constructive trust and are now putting into this court case. And then also that there's been no lawful executor, or executrix as the case may be, appointed to take care of the affairs of the estate. And so this is part and parcel of the presumptions. And there's a lot more presumptions than that, but those are basically the main ones. So I'll restart here. So under the Roman civil law, you are considered incompetent, unable to handle your private affairs. So the trust is involved as a third party in all your private business affairs. Under public federalism, in the beginning, business and economic associations were formed for various advantages. There was no compelled performance because all relationships were based on bilateral contracts with full disclosure and understanding by the parties involved. When a dispute arose between parties in a state, the courts ruled on the contract pure and simple. No codes involved. No implications to be explored. Likewise, when disputes arose between parties from different states, the federal courts were the referees for helping solve the problem, and ruling was upon the contract, with jury assistance if demanded. Again, without codes, regulations, or revised statutes, drumming up a third-party overseer. And this is the aspect, what he's describing here again is what I call public policy. All the aspects, this is all the aspects of Roman civil law: statutes, acts, ordinances, and codes, right? So when you have these statutes, acts, ordinances, and codes under Roman civil law creating public policy, this is the third party overseer saying, hey, we're not going to allow you to, say, put cannabis in your body, or LSD, or mushrooms, or whatever the hell else you want to put in your body or use it for. And so they say, you do not have the right to do so because you're using property that you have not yet claimed. Now, they'll never actually come out and tell you that's what's happening, but that is what is happening. Because you have not claimed your estate, that means you've not claimed your own body, so they'll tell you how to use it. So to continue. So in contrast today, the substance of private federalism is purely the private law or conscience of a private charitable trust. Private Roman civil law of the 14th Amendment, with vested interest called quote-unquote government, moved into the public arena by voluntarily silent acceptance of 51% of the population. This is the aspect of why they keep talking about a democracy, because they've created a democracy over top of, or inside of, if you will, the original republic. And then they've pushed everybody into it without anybody knowing it. So, to continue. Anytime a civil relationship is established, it is based on implied and indefinite trust principles. The result is a government that has created a third-party administrative bureaucracy that spends its time making and readjusting codes and revised statutes that dictate public policy. It is in order to continue the compelled performance of the citizen, the beneficiary, right, the one that gets to go to jail, to service the public debt and thus promote the economic benefits of the government trust. The federal government has become a massive public charitable trust, which is using in excess of 2,000% of every dollar for administration, and the ship of state is not staying afloat. In fact, federalism, private federalism, is apt to appear whenever the strain of preserving a relatively large political unit proves to be beyond the economic and psychic resources of a society. So, quote, I can fight this Frankenstein which the New Deal has created, and which is rapidly gobbling up every vestige of right which the people have and enjoy today. I feel it necessary that the Congress take some steps against this bureaucratic invasion, not only the people's rights, but the right of Congress and every other legislative and judicial branch of our government. You are reducing them, the American people, to the status of serf. And by the way, in this document, there are links, and all you have to do is hit Control and click on it, and there's an index at the end of this document, and I'm just curious as to know where this particular quote came from, so I'm going to click on that quickly. Okay, so these were the words of Mr. Edwin Arthur Hall, and this was March 1st, 1943. Oh, sorry. So January 1st, 43 to March 1st, 43 was the session. So it's a 78 session Congress, first session. Okay, so that's probably where it can be found then, as far as the congressional record. Okay, I just wanted to know who was speaking. So, to continue, take a look at the titles of the United States Code. The last time we looked, there were at least 50 different titles. Of the 50, 22 are public municipal law for private purposes. The rest are simply private law. That's right, private law that has destroyed individualism and the family unit, creativity, and the individual incentive to produce. Private law that has siphoned off all the wealth and natural resources of the wealthiest nation in the world, all for assumed economic benefit. What a sham. Two federalisms. The United States Constitution starts out, "We the people of the United States." This phrase, in referring to laws the commercial government of the United States used to assure a, quote, commercial law system in the American states, close quote, without operation of Roman civil law, except anywhere the tide ebbed and flowed. This is, the Roman civil law was left to operate where it had always been, as a part of the maritime admiralty, sea, and of seaports, and also airports, because it's dealing with commerce. Only the individual, as one people declared in the Declaration of Independence, has the power to determine a republican form of government, as stated in Article 4, Section 4 of the Constitution, by calling on public law for private purposes. This is why the Declaration of Independence was written first. It was the basis of the one people sovereignty, which then set up the Constitution. It was also technically an indictment of the king. If you read it, the Declaration of Independence reads like an indictment from a grand jury. So, just wanted to add that. So, to continue. Before the beginning of the nation and the signing of the Declaration of Independence in 1776, the Roman civil law was well entrenched in the colonies. And this is something that everybody was pissed off about, having to be shoved into maritime amnesty courts and whatnot. This is because it was the basis of maritime amnesty laws that governed commerce upon the seas internationally as well as ports of call. When our founding fathers were planning on a new nation, they understood the advantage of public commercial law for the economic benefit of the American states. However, they did not want any part of that public commercial law to be adulterated with the private Roman civil law. So basically flipping the two, which is what happened, as referred to previously, with the unilateral contracts. Therefore, they met behind closed doors to develop a dual federalism that would assure that commercial law in the American states would prosper without the compelled entrapment of private Roman maritime law that would inevitably continue internationally, because this is the cult of Rome. This is where it came from. Indeed, the main and just to make another point about the difference between Roman civil law and common law, that was a major war. Well, went on for hundreds of years, from basically 1066, when William the Conqueror came over in England and destroyed what at the time they had as their grand juries, which was called the Court of 100. He separated the spiritual and the temporal courts and gave the power of probate, basically, to the priests of El, meaning to the ecclesiastics, or the church, the clergy, and also created what was called the Doomsday Book, which was a massive registry of all the lands in England, because under Roman civil law, this aspect that you do not own something unless it is registered under their rolls, which is where you get that ownership is 9/10 of the law, and that last tenth is that registry. So, to continue here. Indeed, the main task was to get those old centers to surrender certain prerogative, and the effect at reassuring them led to lingering ambiguities in our use of the term federalism. In itself, this has to do with treaties or alliances. The neutral use at Jefferson Papers 1:311, but there was an emphasis in the 1780s on the ties that connect those under treaty, on union and united force, as the term federal, i.e. covenant theology. Federalists were therefore thought to stand for federal power over against the states. But in explaining their position, Madison and Hamilton labored in the Federalist Papers to show the states they had nothing to fear from this central federal power. Thus, federalism has come in modern parlance to mean the division or dispersal of central power. Those who opposed a Bill of Rights at the Constitutional Convention, including, at first, Madison himself, who drafted and steered through the final bill, were assuming that the individual was already protected by the state's bills, meaning the state's bills of rights, that the central government could not reach the individual except through the states, which had put impenetrable barriers around individual rights. Now, that is technically correct, but what this sucker, Hamilton, made sure to put in to the federal constitution, that's not so, you don't see it so much in the original state, particularly the original state constitutions, is this idea of implied powers, and also the total coming over the top of the states by one thing, which is the Commerce Clause, one single thing. And that's what this bastard Hamilton and the rest of them were well aware of what they were doing. They knew what they were setting up. They were allowing their Khazarian mob bankers a way back in through the back door, if you will. And Hamilton was one of their agents. So anyway, it's a good thing Burr shot him. I just wish he would have shot him sooner. Thus, our forefathers clarified the federalism confusion by establishing two federalisms that would exist side by side. One would be private federalism that had come in with the international trade under maritime amnesty laws based on Roman civil law. The other would be a public federalism of the new commercial law in the American states. This federalism would be based on the general common law and its sovereignty of the individual citizen being maintained by public laws for the private use of the individual to conduct his business, basically however chose to do so. And this little table here is an interesting read because it shows the dual federalisms compared, the side by side. And so, one, Erie Railroad versus Tompkins, a lot of people know this case, individual subject to the political commerce under the private law merchant. This was the case that they did after they basically set up and got everything started after 33, when they basically stole everything and said, here, we're going to give you the benefit of using our paper script, which is what Mandel Edward House talks about in his quote. What he's talking about here, the aspect of political commerce under the private law merchant, this is what you're subject to. This other one over here, Swift versus Tyson, individual subject to civil commerce under the public law merchant. The aspect that you have the right to have a dual contract and that there's no third party basically stubbing their nose in here. Public Social Security Trust. This is a maritime insurance for limited liability required under international law. Individual is considered common carrier. All carriers must have insurance to cover costs of involvement in joint venture for profit. A debt never paid. So the opposite of that is just basically negotiable instruments. No limited liability interference. All debt must be paid. So over here, you're operating in basically a bankrupt system that's all been put into a trust, and then you yourself are also then put in to another aspect of a trust under the Social Security situation. On this side, all businesses and trade overseen, regulated by third-party administrative trust who take a piece of the action. This side, the common law side, no third-party intervention, Article 1, Section 10 in full force for individual, i.e. state cannot interfere in the obligation of contract. This side is the 14th Amendment citizen. This side is the non-14th Amendment citizen. Because it's the 14th Amendment that you get stuck under to being subject to the jurisdiction of Congress. That's what the 14th Amendment says. It says that people that are citizens of the United States are either born or naturalized and subject to the jurisdiction thereof, meaning of Congress. So if you're born or naturalized and not subject, you are not a citizen of the United States. And that would be, obviously, on this side, the right-hand side. So this side, Roman civil law side, private enterprise, choices based on what agency's administrative rules code allow. Common law side, free enterprise, liberty of choice in all areas of life without government interference. This side is the New World Order, actually administrative bureaucracy based on the Old World Order. And this is the common law side, is the Republican government guaranteed to the states as per Article 4, Section 4. A few more cases here. A case in admiralty does not in fact arise under the Constitution or laws of the United States. American Insurance Company versus Cater. That's 1828 case. Also Clearfield Trust. This includes the state of the District of Columbia. D.C. is considered a state in international law. It might be considered a state in international law, which is important because you have to think about that, but D.C. is not considered a state of the Union. So when you think about what it says in Article 1, Section 10, where it states that no state shall make anything, no state shall, and then there's a long laundry list, and then one of them is, shall make anything but gold and silver as tender of payment of debt. Well, guess what? The District of Columbia is not a state as per the Constitution, which is why they're getting away with what they're doing. Because they're a private international city-state, just like the Vatican or the City of London. Okay, so to continue. The uniqueness of our Constitution allows this dual federalism. It allows the individual the liberty to function within the public laws and the separation of powers, or it allows for the individual to bind himself or herself by unilateral trust contract arrangements. Thus, the word federal in the American states refers to the dual federalism, as distinguished in Swift versus Tyson, or Erie Railroad versus Tompkins. We much remember the state courts handled federal questions in the beginning of the nation. As commerce between the states grew, Swift versus Tyson was designed to protect the people of the several states from the Roman civil law that was operating under maritime admiralty jurisdiction outside the Constitution, where the tide of maritime admiralty law ebbed and flowed with international trade, basically meaning on the seas. The dual federalism was termed by our founders as the New Order for the Ages. Today, we hear our leaders using the term New World Order However, it is being used to create the old world order and its inquisitions under Roman civil law based on IRS 1040 form, properly known under the government title of recapture property. Post limine equals Latin for bring home the property. And another point about 1040 forms and W-9s also. Both W-9s and 1040 forms under the IRS are not actually income tax forms. They are actually gift and estate tax forms. If you look them up, they're Class 5. And Class 5 is gift and estate tax. So why are you paying a tax for the use of your own property? Again, it's because you haven't claimed it. So, and it's interesting, the aspect of post limine, the Latin term, bring home the property. This is what everybody should be doing. Everybody should be bringing home their own property, starting with their entire estate and their body, which is what we do with the Vocational Science Freedom, with the Vocational Science Freedom Status Doc Set. It establishes your claim to your estate. And does a lot of other things. Also points you executor of the estate. It has a proof of life and proof of age inquest, which is part and parcel of some of the presumptions that they put over you, particularly the incompetent presumption, the presumption that you're an infant, and the presumption that you're dead to the law, or that they don't know where you are, right? So, to continue. So remember, there are two kinds of taxes, direct and indirect. Direct taxes are used to produce revenue for a constitutional government, public federalism. Indirect taxes are used for controlling human behavior and wealth. So, you cannot have any constitution, state or federal, doesn't matter. They all say that if you have a direct tax, it must be what's called apportioned. So what does that mean? It says somebody has a direct tax on you, meaning they're taxing everyone, a direct tax. Then the proceeds for that tax must then be able to be used or enjoyed by also everyone. So everyone puts in and everyone gets the benefit from it. Okay? So if it's a direct tax, it has to be apportioned. So you can't have a direct unapportioned tax. You can have an indirect unapportioned tax. That's fine. And an example of that would be a tax on tobacco and alcohol, right? So the feds put a tax on tobacco and alcohol for just whatever reason they can, just basically because they feel like it. And the point is, you do not have to pay that tax. That's an indirect tax. You could choose to grow your own tobacco. You could choose to distill your own alcohol. Completely lawful. You could do that at your house, do your own thing. That way you do not have to pay the tax, right? So that's an indirect tax. So that's the difference. It's important to understand that, how they're going about this, because they're doing direct taxes with the aspect of the IRS, but they're unapportioned. So, and it's not like the Supreme Court hasn't also said that in multiple different cases. The Supreme Court has even gone so far as to say that the 16th Amendment created no new taxing powers, which of course it didn't, because the only people that are getting taxed are basically what's called federal personnel. But everyone who is considered federal personnel is everyone who has a Social Security account, because that is considered a deferred retirement program. And if you look it up in the United States Code, I forget what section off the top of my head, but it defines federal personnel as one who has a deferred retirement program from the federal government. Well, that's exactly what Social Security is. So they're direct taxing everyone under the presumption that you are federal personnel, and that's how they're more or less getting away with it. Okay, to continue. It is wonderful how preposterously the affairs of the world are managed. We assemble parliaments and councils to have the benefit of collected wisdom, but we necessarily have, at the same time, the convenience of their collected passions, prejudices, and private interests. For regulating commerce, an assembly of great men is the greatest tool on earth, old Ben Franklin strikes again. On to the 14th Amendment. So, we have reached the point where we must bring in the whys and wherefores of the 14th Amendment. For it is the key that has unlocked the destruction of American economy and your individual liberty. Even so, our government is still bent on exporting its principles to the world as the New World Order. In reality, the supposed New World Order is not anew. It is nothing more than the old world order of Roman civil law in a new disguise, continually making and adjusting public policy. I would add here that it is the Luciferian communists that are perpetuating the New World Order. And what they want is any system that will oppress and control people, whether it's outright communism, like how the Luciferians have done right now in China, where they went in and made China communist, or what they did with Russia when the Bolsheviks went in and slaughtered all of the Tsar's family and turned it into Luciferian communism. Or if they're taking it from the other direction, which is an aspect of socialism or democracy, if that's what they're trying to spread now, where they're using Roman civil law to control everything, because that's all they care about. All they care about is establishing a Roman civil law system in every nation so that they have absolute control of everyone, basically all the citizens, everything. But giving them the guise that they have the capacity to change their leaders, meaning we'll allow you to vote, but it's kind of like in this country voting for the president, because in case you don't know, it doesn't matter what you do or don't do as far as voting for the president of the United States is concerned, because it's the electoral college that actually determines who becomes president. They don't have to. And so therefore your vote, quote unquote, for the president of the United States is actually meaningless, because it only comes down to how the electoral college votes that makes or decides who becomes president. So in that sense, this is what they're doing with everyone across the entire planet. Every single place where they have this New World Order set up, they will also have a central bank. I think it was Bush that called when he talked about the axis of evil. What the axis of evil was just basically every nation that didn't have a central bank yet. That was it. That was what the axis of evil was. Surprise, surprise. So, okay, so to continue here with the 14th. So the 14th Amendment purportedly became, because it didn't actually, the 14th Amendment was never properly ratified, in case people are not aware of this. And there were even discussions, there've been discussions as late 1960s in congressional hearing that, and actually on the floor of Congress, where people were debating this and saying, look, the 14th Amendment was never properly ratified. And they were trying to do something about it. Never did anything about it. But the point is that this is a known thing, that the 14th was never properly ratified. So anyway, to continue. So the 14th Amendment purportedly became law, Roman civil law that is, in 1868. But the stage was set years, and in some ways decades before, of the various factors in the history of the U.S. that built the momentum to bring in the 14th Amendment. Probably one of the first was that the Constitution made it plain that every citizen had the right to contract away his personal and absolute rights. See, now that's another important part of what they were talking about regarding the right of contract. It doesn't say in the Constitution that you're not allowed to enter into a stupid contract. It says they do not have any power to abrogate the right of contract. So if you choose to contract away your personal and absolute rights, that's lawful. And that is what everybody is doing. So to continue. That is, anyone could literally bind themselves away from the absolute rights under the Bill of Rights anytime they wanted by private contract. They would operate outside the Constitution by contract if they desired, because the law was theirs. Right? There is a maxim of law that states that the contract makes the law, which is true. Two people write up a contract. That contract is basically private law between them. And that's perfectly lawful. There's no problem with that. You enter into it all the time, particularly every day when you're using some software, usually. You have what's called a user and license agreement. When you use that software, meaning when you take the action to use their product, you are agreeing to what it says in the user and license agreement. You shall not mess with the code, you shall not sell it, or whatever else it might say. And then there's also, in those contracts, there are penalties and ways of coming to conclusions for any breach of the contract. Usually, it's binding arbitration, which is exactly the way that we've set up the vocational science of freedom status docs. You claim your estate, you put them under a user and license agreement, basically for your entire estate, and say, look, if you're going to administer my estate, meaning if you're going to use my software or administer any part of my estate, and I'm using the example here as the analogy to the user and license agreement for the software, if you do that, you agree that you are a appointed trustee of the estate and that I'm the executor and that you are under my executive orders at all times, and that you have to put up a $300 million bond for potential fiduciary malfeasance of anything that you may do with my estate. Because guess what? I don't trust you. Even though I'm appointing you as a trustee, I know you're a shitty one because all you've ever done is steal from everyone. Meaning, if they happen to be a public servant, all they do is steal. So that's what government's entire job is to rob from you. So I know that you're a thief, so therefore I'm forcing you to put up a bond for potential fiduciary malfeasance of anything that you might administer of my estate. If you fail to put up the bond, you agree that I have the right to take you to binding arbitration for the full amount of the bond, whether you put it up or not, by simply you failing to uphold this contract. And that's how you enforce your claim on your estate, by the VSOF paperwork. So anyway, I just wanted to put that in there. The understanding that you can contract your rights away, and that what I created was I created a situation where I'm doing exactly the same thing to them that they've been doing to us. But I wasn't very nice about it. So, to continue. Okay, so however, in the opposite vein, they could walk right back into their constitutional government any time. And this is what we're doing. We're walking back in. This was called the right of expatriation, but more on that later. Another factor contributing to the bringing of the 14th Amendment had to do with both slavery and the corporations before and during the Civil War. In fact, the Civil War figures very prominently in the 14th Amendment because it was used as a cover for control maneuvers going on in the corporate backrooms of our nation, especially in the North. On the other hand, the slave issue was used as a con before, during, and after the war. In 1851, an act was passed called the Limited Liability Act. This act provided protection for owners of ships whose cargo and or ship was lost at sea. The ship owner and investors were required to purchase maritime insurance. Sound familiar, right? Like how they force you to buy insurance on your car now. So if a loss was encountered, it would be easier to deal with if the loss was spread around. This was basically, and this is my own interjection here, is that they were doing this because it was the insurance companies that basically forced the federal government to say, you need to pass this act, right? It was the insurance companies that started all this. People think that the banks are like at the bottom of the dirt. They're really not. The corporations that are at the very bottom of the dirt are insurance companies. That's where all of this really got going. So I just wanted to make a point of that. So to continue. So from this, the inland corporations saw an opportunity to advance if, some way, they too could have the benefits of maritime limited liability operating in their behalf. They saw limited liability as a way to take more risk to advance their profits, making the corporation king. Keep in mind, during that time of our nation's history, the North had become the industrial center while the South had remained the agricultural center, dependent on slaves as their basis of labor. Because the social issues of slavery had been making more noise, what better time to turn the problem of physical slavery into a tolerated economic slavery by bringing in the law of the sea over the land? If a war results from the slave issue, what better way to help strengthen industry in the North than to use the stimulus of war? By pushing the problem of slavery, the real issue of economic control by private corporate structure could be advanced unnoticed. The first phase of a bait-and-switch tactic. So with the Civil War and the northern industrial base primed, the slaves were now free of being chattel property. At this point, corporate Big Brother made a calculated move. Since the freed slaves, as well as the rest of the citizenry, were ignorant to how their freedoms were maintained, it was a perfect time to activate the second part of the bait and switch maneuver. This was to set a law in motion with a lot of congressional fanfare that appeared to assure the freed slaves that they had all the civil rights of everyone else. Thus came about the Civil Rights Act of 1866, which was private or non-positive law. The basic problem with the act was that it had no jurisdiction over the slave at all. But the lawmakers sure made it look that way. You see, it was private law that only affected those who were in contractual relations with the private corporate structure of the United States government. None of the freed slaves had any type of license with the United States government, so it did nothing other than play on their ignorance and made them think that it did something. It also affected few of the rest of the population for the same reason. It had ended up to be as a law that had few citizens in its jurisdiction. However, the act had a more indirect effect on the future freedoms of everyone as we look back. For those it did affect, those holding licenses under contract, including federal employees, which again are now called federal personnel, with the United States government, it did two primary things. First, it took away absolute property rights in personam. Second, it replaced them with personal property rights in rem, regardless of race. That is, the Civil Rights Act of 1866 moved everyone in its jurisdiction away from real property law and established them in personal property law, outside the protection of the general common law. And to make a distinction here, and to kind of help understand what he's talking about, is that what it did was, under the common law, you have, let's just take the example of land itself. So under the common law, you have what's called a allodial title. A allodial title is the highest title you can ever have to land. It means you can do anything you want to on it, and it means that you own the land from the top of it all the way to the center of the earth. It means you can mine anything that's underneath it. Under common law, you have a allodial title. So you have full title, everything, the highest title that can be. Under Roman civil law, what they do is they split the title. So you have what's called a legal title, and you have what's called an equitable title. The one with the legal title is the one who actually owns the thing. The one who holds the equitable title is the one that has the right to use the thing, but does not own the thing. And a good example of that would be your car registration. The allodial title to your car, you, most likely, do not have. It is called the Manufacturer Certificate of Origin, MCO. And it is with the car when the cars first come off the manufacturing line. And what happens when you go to the dealership is that they'll fax that MCO to whatever state, Secretary of State, you show them a license for. Why? Because you have entered into a contract, holding license under contract, right? What we just read. And that then tells the dealership that that's the entity, the government entity, that needs to have the actual title. You presented them with a license saying, Daddy said I could use this. And they say, okay, then we're going to give the title to Daddy. You see how that situation is the same? So I just wanted to make a point of that to give you a real life example of what they were just talking about in this paragraph. Okay, so to continue. The only problem with the Civil Rights Act of 1866 was that it did not have enough jurisdiction over the majority of the population. Right, because not that many people had licenses. Therefore, Congress began another maneuver under the influence of private corporate special interest. It began to make the public think the act was not permanent enough, and that there was the potential of that another Congress could be impressed to remove the civil rights. Therefore, the only way to assure permanent civil rights was to make an amendment to the Constitution. The same Congress, shortly afterwards, evidently thinking it unwise and perhaps unsafe to leave so important a Declaration of Rights to depend upon an ordinary act of legislation, which might be repealed by some subsequent Congress, framed the 14th Amendment. What an assumed noble reason. Assure civil rights by adding an amendment to the Constitution. Who could be against civil rights? Question mark. After all, isn't that what the country was all about? So we now have the 14th Amendment. It is extremely unfortunate, as we look back at the racial cover that was used to get the amendment into law. We continue to see, even today, the same use of racial issues to cover an undercurrent of corporate private law being used in the public sector for exploiting the population. The 14th Amendment is a setback to proper government. This operation of the 14th Amendment runs counter to the ideas expressed in the preamble of the Constitution itself. It does anything but promote domestic tranquility. They, the Republican Party, knew what they intended by the vague terms of Section 1 of the amendment. They knew it could be interpreted so as to extend far beyond the Negro race question. They desired to nationalize all civil rights, to make the federal power supreme, and to bring the private life of every citizen directly under the eyes of Congress. This result was to be obtained by disenfranchising the whites and enfranchising the blacks. It meant the death knell of the doctrine of states' rights and ultimate nationalization of all civil rights, and the consequent abolition of state control over the private rights and duties of the individual, meaning that the state constitutions were supreme and that all of the matters would be under common law and be in control of the people still. To continue, it meant the passing over of the police power of the state into the police power of the national government, thereby giving Congress undefined and unlimited powers whereby it would be enabled to enter fields of legislation from which hitherto it had been barred. The states of this union were never sovereign. Neither is the federal government sovereign. Sovereignty is and always has been inherent in the American people. This would be a different matter if the 14th Amendment presented to the courts only questions of law, but this is not the case. As a rule, when the Supreme Court declares a new state law unconstitutional under the amendment, the 14th Amendment, what it really does is not to decide a question of law, but a question of governmental policy. The primary purpose of the adoption of the 14th Amendment was to elevate the Negro to a place of equality with the white people and to protect him in his newly given rights. In its attempt to carry out this ideal, Congress was effectually restrained by the Supreme Court. Consequently, as related to the Negro race, the amendment is negative and non-automatic. It has failed of its purpose because there is no federal power to enforce it, and because the Negroes have not been qualified to gain for themselves the ideals which it seeks to enforce. When they do become so qualified, they will have no need of the 14th Amendment. On of the immediate purpose of the adoption of the 14th Amendment was to assist in destroying the power of the Democratic Party in the South, and in its place to build up Republicans. This result was to be obtained by disenfranchising the whites and enfranchising the blacks. It was a nationalization of civil rights. And the whole aspect of getting people into and under the contract was extremely important. And you know what? I guess I will, because this goes on for quite a while with the 14th Amendment. So I just realized we're about up to time here. So I'll come back up here and we'll finish out. I'll go ahead and finish out the section here. Okay, so I'll make a note here that we can come back to. And I'll pause here because the rest of it will be talking about the 14th Amendment for, looks like, another 4 or 5 pages. So anyway, one other point I want to make about the 14th Amendment. One, it was never properly ratified. Two, the southern states were denied suffrage in the Senate when it was passed, because what the North had done is that when the southern delegates basically refused to come back to the Northern Congress, and when that happened, the North, basically the industrial Khazarian mob, banking, Luciferian fucks, decided to just appoint Southern congressmen and Southern legislators and then had them turn on and pass the 14th Amendment. So there was never any lawful passage of the 14th Amendment anyway. And also, another thing I want to bring up about the 14th Amendment is that we've been talking about contracts here, and they've been talking about how the whole aspect of the 14th Amendment was obtained by disenfranchising the whites and enfranchising the blacks, right? Okay, it's this idea that they're going to do this. Well, here's the thing that the 14th Amendment actually did, which they might get into later, but I'll just bring it up now. So what actually happened was that the slaves basically went from being private property to being public property, meaning that they were now basically owned and being administered by the federal government when they agreed to enter into licensure of whatever kind. And a lot of the times, or it started back then, but it wasn't very prevalent back then, but at least it started back then, was that one of the licenses that they came up with was called the marriage license. And at that time, if you were white and you wanted to marry a black, or if you were black and you wanted to marry white, you had to get a license for it. It was considered literally, and I'm not trying to be racist here, but this was what they saw it as. It was an aspect that they considered it to be animal husbandry, and that they had the right to demand that you pay a license for the use. As I said, because the slaves went from private property to public property, you now have to ask daddy permission to use that property, meaning to have sex, to make babies, because Caesar owns that property now. And this is exactly what they've done. And now everyone who goes and gets a marriage license is now considered to have entered into one of those contracts on the state side, and so therefore is considered to be subject to what the laws are, because you went and begged for the license. Because there's a maxim of law that states, he who begs knows what they're begging for. So if you go to Daddy State and say, Daddy, may I, please, then that's a presumption on your side that you know what you're begging for. That you believe that you have to ask permission to do, A, B, C, D, whatever it may be. And that in doing so, you have subjected yourself willingly to the jurisdiction. And so with that, I think I will pause here for the night. So we made our note. And if anybody has any questions or comments, feel free to go ahead and direct message me afterwards. But I think we'll call class here. And I would like to make a mention that the Wednesday night open roundtable coming, which would be the 14th of September, we're coming up here on, I am going to redo the Edward House quote class, but in a much more thorough way than what I did with the interview on Patriot Soapbox back when I did do it. I'm going to cover all of the vocabulary words, and I'm going to make it almost a complete class, and we will probably go much longer on Wednesday night because of that. So with that, I'd like to thank everyone for coming. This has been Vocational Science Freedom Saturday Night Civics and Sovereignty class, and we have been reading from the document titled U.S.A. The Republic is the House that no one lives in. And we'll continue reading this on Saturdays until we get done with it. And so I'd like to thank everyone for coming. I hope everyone has a wonderful rest of your weekend. And until Wednesday, stay safe and stay sovereign.